number 6, People of the State of New York versus Rafael Then. Good afternoon, counsel.
Good afternoon. May it please the court, Patricia Pasner with Appellate Advocates for Appellant Rafael Then. I'd like to reserve 2 minutes for rebuttal, Your Honor.
You may.
Okay. This court in Roman held that a defendant is presumed innocent and is entitled to appear in court with the dignity and the self-respect of a free and innocent man, and to require him to appear in convict's attire denies him of that right. In this case, appellant was similarly
Does it matter,
forced.
counsel, whether the jury or anybody who would have to make a decision about the defendant's fate knows whether he's in convict or she is in convict attire, as you pointed out, as you put it?
There's no dispute that this was identifiable prison garb here, Your Honor. The court, prior to voir dire, understood it to be correctional wear.
Yeah, but I think the question, without trying to put words in my colleague's mouth, is whether it matters whether the fact finders or potential fact finders actually knew he was wearing those clothes.
I believe that
Whether they were visible.
That they were visible, and in fact,
No, the question is, does it matter? Does
it
make
matters
a
that there is a
difference?
possibility that they could see the clothes.
Any possibility means per se reversal, even if there's nothing in the record to show that they did or could see it.
The mere possibility, yes, requires reversal here. I would point to Cruz there in a shackling case that showed that unless the record conclusively determined that they were not visible, this court cannot hold that there was not error.
Does
here.
it matter that the appearance in prison attire was for a portion of a trial day?
No, Your Honor. First impressions matter here. They met the defendant. The defendant was presented to them dirty, disheveled, and in prison attire. From then on, this is the lens that defendant was going to be viewed through. That he wore civilian clothes following those days does nothing to cure the error,
Also,
because
what in the record suggests that these jurors on that half day could see that your client was wearing prison pants?
it's actually the court's own record that shows that visibility was a possibility, because it says, although unlikely unless a juror strained, means that visibility was a possibility, because if one juror was intent on looking at defendant, then the pants were visible. And I would like to point out that the prosecutor, during voir dire, made it a point of pointing out the defendant's disability, because the defendant was in a wheelchair, in fact, made his legs much more noticeable.
Counsel, you are citing the shackling cases for saying the mere possibility, but do you think the mere possibility language in the shackling case is somehow also a product of the fact that we do apply harmless error in the shackling cases? I mean, what you want is mere possibility, absolute error.
Yes, I believe that the visibility part of that goes to whether an error has been established. So
But you don't think that we might say, okay, mere possibility in a shackling case may get you an error, but that error is going to be analyzed under harmless error analysis. You want both of those parts. You want the mere possibility being automatic reversal.
I want what this court held in Roman, which was that once the error is established, that a defendant is forced to appear in identifiable prison wear, that there is a reversal without harmless error analysis here.
Didn't the court also say in Roman that there might be situations in which that would present problems, practical problems of implementation of a request that a defendant not wear prison garb? Doesn't that kind of at least suggest that that we weren't talking about a rule of per se reversibility?
No, I think that they were leaving open the possibility that there may be some a defendant that perhaps would want to wear prison attire. You know, they deal with that in Estelle, where if you're not compelled, then it's not a per se reversible error. But once you are compelled, it is so. I think that's the
Although the
opening.
language refers to implementation of a defendant's request that he not wear prison garb, so I'm not sure that makes sense.
I think that is foreclosed by Estelle. By the moment that Estelle wrote that there is no justifiable state interest in wearing prison garb, I don't think that now we can go back and find that there might be. Appellant timely protested. He said that he was wearing orange pants. He didn't look appropriate. He recognized that he was meeting the jury for the first time, and this was his life on the line. And while he requested a 2-day adjournment, defense counsel did modify that and ask for just a mere afternoon, and in fact, defendant was able to obtain civilian clothing the next day. And so this error could have been completely avoided by a mere afternoon adjournment. Here, harmless error doesn't apply under Roman, and I would also point out that this court's reading in Nelson also suggests that the framework requires per se reversible
You don't think that Roman
error.
is distinguishable from this case at all? In Roman, wasn't the defendant required to wear prison garb during the entire trial?
Yes, that's correct. They were, but I would just say that once the error is established, it's established. The jurors know. The jurors know who he is, who he's being presented as, a criminal, a obviously guilty person. To be reminded of that is what Roman is, but that
Roman
doesn't erase
also
what they know.
But Roman does not get to the harmless error prong at all. In fact, it's not mentioned. Roman's a one-paragraph per curiam opinion. It doesn't. So you're saying you want what's in Roman, but you're saying you want a no harmless error rule. That's not Roman. I mean, we didn't address it.
Right.
So in Roman, as the judge was saying, Judge Abdeslam, it's a continuing presence in front of the jury. We didn't get to harmless error, but now you want a mere possibility, no harmless error.
I want
And you said you want what's in Roman, but I don't see that as Roman.
I want this court to hold that there is an error. Error was established, and just as in Roman, reversal is required.
Counsel,
Without a
do
harmless error. I'm sorry.
you care to get to the issue regarding the ex-girlfriend's testimony?
Sure, Your Honor. The complaint here is that appellant was deprived of his due process right to a fair trial when the court allowed testimony from appellant's girlfriend that he always carried a gun
Was there
during the
an
month.
objection to that? I haven't found anything in the record that indicates that it was preserved, but.
I believe that the defense counsel asked that mention of the gun that he was carrying.
Well, there certainly was an objection to admitting the gun itself, and in the end, the court did not allow any reference to finding the gun when he was arrested.
Right.
But the remainder of this testimony, I didn't see any objection.
I believe that you can imply from defense counsel's objections that to the gun being put in and mention of the gun is the girlfriend's testimony about the gun throughout the month.
Because I thought it was aimed at the fact that he was acquitted of the charge of having the gun at that particular time, and that was why he was focused on the gun at the time of his arrest.
Right.
But that wouldn't preclude evidence of his having a gun on some other occasion necessarily, and I just, okay.
Okay, and
I
do you
see.
want me to address the actual issue at hand? Okay. It was admitted, according to the court, under the identity, narrative, and access. None of these were appropriate here. This did not go to ID. For ID, you need to find something unique about the prior crime and the current crime. Here, there was nothing unique about this gun. It was a black gun that was 6 to 7 inches long. The complainant was robbed by a black 9mm gun. There's no unique characteristics about that, nor did it complete the narrative. It had nothing to do with the date of the crime. It had to do, and specifically, I believe the girlfriend did not see the robber. The girlfriend did not see defendant on the day of the incident. Access was just not necessary here because the charges that the defendant faced were that he displayed a gun, the robber displayed a gun, rather than what appeared to be a gun, rather than an actual gun here. This was not harmless here. This was a very quick eyewitness, eyewitness robbery. It happened very fast. There was a weapon involved, so clearly weapon focus was at play here. And there was no other identification, including surveillance video. It was too grainy to make an identification here.
Thank you, counsel. Mr. Fidenzi?
Good afternoon, Your Honors. Joseph Redenzi for the people of the state of New York. The defendant here got a fair trial. I grant you, maybe it wasn't perfect, but it was fair.
Let me ask you this, Mr.
Sure.
Firenze. Do you, would you characterize the appellate division ruling as a harmless error ruling?
Essentially, yes.
Okay, so that means, in essence, that they credited Supreme Court's statement that you had to strain to see the orange pants, which means that if you strained, you could see the orange pants. So therefore, they found that so they were therefore identifiable, but it was a minor error, and it was a harmless error. And it didn't have a significant effect on the outcome of the case. Is that how you characterize it?
I don't think I would, Your Honor.
Let me just explain the reason I ask.
Yes.
I'm curious, what are we to do? Are we to say, number one, if there's an affirmed finding of fact that this was not an identifiable piece of prison clothing, then I don't think we really have to go much further with this.
Mm-hmm.
But if that's in question, and that if you can fairly or reasonably argue that it was identifiable, then the question for this court becomes whether or not then it's error, so is it harmless error or not? And we're really focused in on whether or not harmless error can apply in this setting.
Yes,
That's why I'm asking you that.
Yes, I understand, Your Honor. Of course, it's understandable that many times an appellate court, especially a very busy appellate division like the Second Department, will base its ruling on what it thinks is the strongest.
Well, you know, I think, in fairness to them, I think they tried to cover both sides of this question. You know, it's a prudent thing to do when you're in appellate court, but I'm curious to know how you see it.
Well, I don't see it as, first, I don't think that statement, that if somebody strained, they could see it, means that anyone actually saw the pants. I know that when the assistant DA asked the panel if they noticed anything unusual about the defendant, the only response was, he's in a wheelchair.
I think you're totally right, but all they had to do, either court, was just say, they couldn't see it, it's not identifiable, that's our finding of fact. Nobody said that.
I understand, Your Honor. I've been
So it's kind of simple, that's kind of simple.
Yeah, I understand. No, I totally understand, Your Honor. You know, I've been practicing appellate law for a long time.
Yeah.
And when I get the perfect record on appeal, I'll have retired by then.
Good luck.
Thank you. So I just think that on this record, we should come to the conclusion, and this is the conclusion that I think the appellate division came to, which is that regardless of whether these pants were visible, which we say they're not, regardless of whether they were identifiable, which we say they're not, the fact is this defendant was convicted because of the mountain of evidence arrayed against him. And there's no way this half day of wearing orange pants could have led to this verdict. I don't think a jury, even seeing the orange pants, when faced with this, I don't know what to call it, but an insurmountable.
I happen to think you're right if harmless error analysis can be applied.
Yes.
So that's really the question.
And-
Can it be applied to identifiable prison clothing?
I absolutely think it's in line with this court's jurisprudence. I mean, when I read this court's cases on visible handcuffs, visible leg shackles.
You know, the distinction, though, there is that I think harmless error analysis is correctly applied by this court to those situations because there's an element of a compelling state interest. There's a question of safety there. We don't have that here.
But-
This is the kind of error that, really, there's no compelling state interest in what attire somebody wears.
I quite agree with you, Your Honor, but that goes to whether there's error or not. That analysis goes to whether there's error. That analysis did not apply to whether it's harmless. I understand that there's no compelling reason to wear prison clothes, and that in the other cases, in order to decide whether there was error by the trial court, one engages in that analysis. But I don't think it has any bearing on harmlessness. I think that it would be, as I said in my brief, and I apologize for repeating myself, it's counterintuitive to say if a jury erroneously sees leg shackles or visible handcuffs, the error can nevertheless be harmless, but to say that if there's an error in wearing prison clothing, that cannot be harmless. I don't think those things jive together. I think it would
I'm
lead to...
sorry, I'm not really understanding,
Okay.
perhaps I'm just not hearing you clearly, understanding the argument about the analysis in those prior cases goes to the compelling interest and error. Right. Isn't the error whether or not you shackled them or didn't shackle them? Or you
Yes.
handcuffed them or didn't handcuff them?
Correct.
And you could or couldn't? So, okay, walk me through again your argument of how, in those examples, those prior cases, what's at play is the state's interest, which is not the case in the garb. Either you're wearing the garb or you're not. Isn't that the error?
Yes. But the point I'm making is that if you can have error in shackling somebody in front of a jury
Yes.
and yet hold the error to be harmless, then you should hold that visible prison clothing can be harmless also.
Well, that's because the compelling state interest of safety in the courtroom may require shackles for certain defendants. And you don't have that, and that makes sense, so that's logical. So even though it's error, you find that shackles are required because of an uncontrollable defendant for some particular safety reason, then the judge can make an appropriate determination on the record, and you're allowed to go ahead and do that, even though it clearly impinges on their rights and implies that it undermines the presumption of innocence. There is no compelling state interest for safety in the question of clothing. So that's why I focus in on the harmless error analysis.
But counsel, I'm sorry, I understood your point in that compelling argument, a state interest argument to be, that's balanced in part one, where you say the person shackled to the table, is it error? And you say, well, he was violent, he was, so there's no error. We don't get to harmless error analysis. In the prison garb, you don't have that first part. There is no compelling state interest in having someone in and sits there in an orange jumpsuit. So it's error. Then you get to harmless error.
That is correct. That is the way I think the analysis proceeds.
But you're not arguing that it's per se error if, for example, if the defendant here were seated at a table and there was, one of those black curtains around the entire table and he was seated in his wheelchair and there was absolutely no possibility that he could be seen, then it wouldn't be error just because he was wearing the pants, right?
Correct. There are situations where a court could find that there was no error. I'm simply addressing the hypothetical scenario of if this court were to find there were error here, that, just like the appellate division did, it would apply harmless error analysis and conclude that in this case, this half-day possibility would
But
constitute...
again, this is why I'm asking you, I do not understand the argument about the compelling state interest, because once you've decided there's an error, that is no longer relevant. Now you're deciding the impact of the error. So what is the compelling state? It's an error or it's not an error, and then you move on from there.
Yes, Your Honor. I understand that. And so what I'm saying here is that if a court were to find that there were error, it could nevertheless be deemed harmless. And this would be an appropriate case for that because there's overwhelming evidence of guilt here. And the defendant, we understand. I mean, the judge here was obviously not pleased by having this defendant produced late and in prison clothing. And it did what it could, and I think it did it satisfactorily. It waited till he was wearing a black knit top. It made sure that the wheelchair was pushed under this, as the court described it, very wide table. And it did what it could to make sure that there was no error here, that the jurors could not see these orange pants, which, in any event, didn't have numbers, didn't have stripes, didn't have anything. Yes, the participants, the judge, the prosecutor, the defense attorney, everybody knew they were prison pants, but that doesn't mean that a juror upon seeing a man dressed in a black knit top with orange sweats, would come to that conclusion. I see my time is up, and if there are no further questions, I
I
will
would like you
rest on
to
our brief.
address the second half of the argument, though, counsel, about the gun testimony coming in.
Oh, yes, Your Honor, I'd be pleased to. The main problem with that issue before this court is it's not preserved. His objections were largely about the testimony, any testimony that was connected to the October 27th Bronx incident. He never objected to the ex-girlfriend's testimony about what she saw before the Bronx incident. In fact, that's why when you look at the record, you will see that the prosecutor was very careful about understanding the scope of this ruling and limited her testimony to events before October 27th. And as far as the merits goes, I think the trial court and the appellate division were all correct that this was relevant evidence whose relevancy exceeded any prejudicial value, and so the ruling, I believe, was correct and should be affirmed.
Thank you,
Thank
Mr. Fidenzi. Ms. Pasner?
Shackling and prison garb are different. Shackling, there's sometimes a necessary state interest here. That presupposes both that there may be at times misapplication, and it presupposes, therefore, that harmless error analysis may apply.
Doesn't that cut both ways? Because to me, seeing a defendant in shackles would be way more prejudicial than seeing a defendant in prison garb.
I disagree, Your Honor. I believe that while shackling, first of all, this court in Clyde said that...
To me, one suggests that this person is in prison, and I think most people understand that sometimes people are held if they've been charged with a serious crime or whatever. The other is that this person is a dangerous person, that this is a violent person. And here, particularly in a case like this where there's alleged use of a weapon or something that appears to be a weapon, I think it could cut both ways.
I don't believe that it's just that he is a prisoner. I believe that it suggests he has a prior criminal record. It suggests that because he's being held, it does suggest that he may have a prior...
Even if you're right about that, how is that more prejudicial than suggesting that here is a person that can't even be freely sitting in a courtroom with court officers and everything around? This person is so dangerous, we have to have him or her shackled.
Well, first, this court in Clyde stated that likely what a jury would say, particularly in a violent crime, is that a person is being shackled for precaution rather than assume independently that he's a dangerous man. That's like this court in Clyde. Second of all, prison garb suggests a flight risk, suggests that he's generally a criminal.
Yeah, but
It's
rationally, shackling just looks worse than orange pants. I mean, if you're sitting there in a jury, don't you think that that's kind of rational? Isn't the real question not that? Because the real question is we apply a harmless error analysis to shackling, and that's because there's a compelling state interest that we're trying to protect in the safety and the conduct of the courtroom. We don't have that compelling state interest in clothing. Isn't that the real distinction? Because Judge Stein, it's hard to rationally argue with what she said. It makes perfect sense. Shackling's worse.
I understand, Your Honor, and I agree that the main argument here is that harmless error is more appropriate in a shackling case because there is sometimes a state interest to do so.
But isn't the problem with that, once you get to the harmless error analysis in a shackling case, you've decided there isn't a compelling state interest? In order to get to the harmless error analysis, you've already determined there is no compelling state interest to shackle the person. Otherwise, it's not error.
I understand that. I think it's just more of looking at the error in a macro way, that we understand that sometimes there's going to be a misapplication, and it still gives the people the state a chance to prove its case, whereas here, there is never a justifiable reason to do so, and that does not then pre-assume the same harmless error analysis.
Thank you, counsel.
Thank you.